You may have noticed that several of Salt and Pepa's albums are currently unavailable for streaming. And that's because they are disputing with their record company over the rights to those albums. And as a result of the dispute, those albums have temporarily been removed by the record company. So Salt and Pepa has sued. Let's take it back to 1986. Salt and Pepa signed and engaged to perform their performances for a producer, and that producer in turn signs with a distribution company. In 1992, that distribution company assigned its rights to London Records, and today UMG has the rights to those recordings. Along the way, Salt and Pepa have become superstars with numerous hits, and according to the complaint, over the last 5 months, they've generated $1 million in sync licenses just for the song Push It. So they exercised their right under 17 U.S. 203 to get those copyrights back 35 years after the assignment. And the effective date for a couple of those terminations for those earliest records should have already passed. They should already have the rights to those records. However, UMG is refusing it, and they've sent correspondence to Salt and Pepa's lawyers with two principal arguments. The first of them is that they don't see in that original contract that Salt and Pepa did an actual transfer or grant, and therefore there is nothing to terminate. And if you don't understand that argument, I don't think it's very logical either. The second is they argue that the works were works for hire, and where something is a work for hire, it's not eligible for termination under the Copyright Act. Now, there are only two ways to be a work for hire under the Copyright Act. Either they were employees working within the scope of their employment, or if it was specially commissioned, that requires a written signing contract that says it was a work for hire. And these contracts did not say that they were works for hire. However, UMG points out that when the producer's company did register the copyrights, they indicated them as works for hire. So that's UMG's argument. The parties tried to negotiate this and temporarily keep those albums available, but those negotiations broke down, so UMG has pulled those records, at least temporarily. That's why it's the two earliest ones, because those are the ones where the effective date had already passed. Those rights should have already passed on to Salt and Pepa. Now, if you're Gen X, I know you have this question. Where is Spinderella in all of this? Spinderella is not a party to the lawsuit. She's not even named at all in the complaint. I did see her name in a couple of the contracts that were attached as exhibits to the complaint. And the complaint calls Salt and Pepa the majority of the authors of the sound recording. So perhaps that has not foreclosed the possibility that Spinderella has her own termination interests, but as of now, she's not part of the lawsuit. My name is Mark Jaffe, Five Bridges Law, representing creatives in California and New York.